Can you lose your rights to your ERISA disability benefits as part of an employment separation agreement? If you're leaving a job and you've been handled a separation agreement that includes a voluntary and unconditional release, you need to stop and you need to read it carefully, especially if you have any claims under ERISA for disability, health, or retirement benefits. There's a recent court case out of New Jersey that shows exactly what can happen if you don't read that release closely. So this is the case of Clyburn versus Lincoln National Life. Ms. Clyburn was an employee at Brother International, the typewriting people. As part of her separation from the company, she signed a confidentiality agreement and a separation agreement. And in that agreement, she waived all legal claims, including any potential claims under ERISA, in exchange for having to repay nothing for advances she had received while applying for her short and long-term disability benefits. Now that release sounds pretty straightforward, but after the agreement was signed and the debt forgiven, she went on to file a claim for her short-term disability benefits with Lincoln. And Lincoln, who was the plan administrator, denied it. And ultimately, this case ends up in court. And Lincoln says, you need to throw this case out because of the release she signed. And the court made it clear that a valid release can bar someone from bringing an ERISA claim. So the circumstances upon which this occurs is going to be evaluated by the court. And what the court is going to do is say, look, is the language in this release clear? Did the employee understand what they were signing? How much time did they have to consider the agreement before they had to sign it and send it back? Did they have a chance to get legal advice? Was there any room to negotiate the terms? Did the company give her anything above what she was already legally entitled to? And so in this case, applying those tests, the court decided that she knowingly signed the release. And the question became, well, does that stop her from bringing the short-term disability claim against Lincoln? And the answer was yes, it did. Now, she argued that Lincoln shouldn't be able to bring this release into the court case because they weren't part of the original claim. This was between her and her employer. But the court said, no. The court fact said it was a distraction and said that Lincoln had every right to interpret the plan and enforce the terms of the release. And in the end, Ms. Clyburn lost her case. You certainly want to understand the terms of any release before you sign it. See what you can do to negotiate exceptions, including any claim for ERISA disability benefits. Consult with an experienced attorney, including an ERISA disability attorney, and then make a knowingly intelligent decision as to whether or not whatever they're trying to offer you in this release is worth what you would be giving up in terms of the value of your ERISA disability benefits. And many times the answer is no, it's not. If you have any questions, call us at 727-894-3188 for a complimentary consultation. We can help you regardless of where you live in the United States and regardless of who that employer and plan or policy might be. 727-894-3188.